our weekly, mostly weekly, Friday privacy chat. We are excited this week because we are buzzing all week. We, I mean all of us in the data protection community who are trying to get our arms around this bombshell of a decision in this Dutch DPA action against Uber. The confusion, the debate, the consternation that seems to be kicked off by this decision, a huge fine on an issue where, although many of us say, well, here's what we would have done, but none of us think that there was actually any clear path forward, and where perhaps with this august group, we'll analyze both a bit of the law as well as the decision and see if we can make sense of it. I'm joined by Dr. Gabriel Zanfer Fortuna, lead for global privacy issues here at the Future Privacy Forum. I'm joined by Odia Kagan, one of our favorite, smartest, bestest data protection lawyers, lead of the practice at Fox Rothschild. She is in the Philadelphia area, and really thrilled to be joined by one of the people who I have learned so much from over the years. If you are watching and you don't know Christopher Kuhner, whose biggest current project, among many other publications, please do Google and read anything he's written. But and we'll drop his most recent opinion on this particular case in the comments here. But the most recent significant work is the commentary on the GDPR that he has edited, written parts of, and coordinated and published. Gabriel is one of the authors of chapters there. The second edition is in progress. Obviously, this case is one that may need to be incorporated. It's worth your time. All right, let's jump in. So very briefly, I think if you've tuned in, you know what we're talking about. If you don't know what we're talking about, Uber was hit with a monumental hundreds of millions of dollars decision by an action by the Dutch Data Protection Authority. Uber has a European entity. It's known as UTI, so apologies for that, but maybe Uber Transport International or something like
Technologies,
that.
yeah.
Uber Technologies. It is a Dutch headquartered entity. The Dutch DPA is their lead authority. They are fully subject to that. That entity is clearly fully subject to the GDPR. They have a DPO, a smart, savvy expert named Simon Hanya. Many of you know him. They have a legal privacy global lead, Ruby Zeffo, brilliant and sharp. They have outside counsel, lots of people working on data protection there. The Uber drivers obviously often have cantankerous relationships with the parent company. They filed a complaint with the Dutch Data Protection Authority about their data, which evidently was heading to the United States. Uber, once upon a time, had standard contractual clauses, as so many companies did. Obviously, the Schrems decision came along and told us all that the current SECs, certainly at least for transfer to the US, were not were no longer appropriate. Much of the world during that time didn't know what to do. Many people ended up using an updated version of standard contractual clauses that were created and promulgated specifically by the European Commission. In promulgating those, they were clear that in their view, these could not be used for transfers when the company collecting the data was collecting data in Europe subject to the GDPR. Of course, they are not the interpreters of the GDPR, but they do have a unique role in both drafting and approving the process of these SDCs. The EDPB did not embrace that view. Of course, the EDPB also has only an advisory role in terms of these opinions. The Many companies simply used the updated SECs, bending to the view of the EDPB. We know, however, that those updated documents were not going to suffice when the U.S. didn't have a improved structure for oversight and transfers and respect for national security and such data. We all held our breaths. Odia is LinkedIn famous for saying, let's, what did you say? Pray and cry.
Cry and pray. Yep.
Cry and pray. We know that the agreements certainly did not save Facebook from significant fines. The U.S. in the end did, of course, work out an agreement. Uber did go into the latest version of the EU-US agreement. The Uber made the decision during that time to rely on one of the derogations. We'll talk about that. And the DPA thought that that was unacceptable, not the right move. All right, Gabriela, fix what hopefully the generic audience following has heard that. Give us maybe a clearer view of the facts and some of the key issues, and then we're going to ask Professor Dr. Kuna to give us sort of the big picture, having had multiple articles analyzing some of the dissonance that exists in the structure of the DPAs and the structure of the GDPR and the structure of the way it's been interpreted that maybe took us to this train wreck of a situation.
Yeah, thanks, Jules, and hello, everyone. Such a pleasure to have the opportunity to geek out with the real voice in real time with top experts on these issues. Just to put a bit more nuance on top of the summary that you gave, let's be very clear that all of this happened in the aftermath of the Schrems II decision of the Court of Justice of the EU, which annulled the privacy shield. And the facts of this particular case concern the period of time when we were in between adequacy decisions for particular frameworks in between the EU and the US. So it concerns that very ambiguous, I would say, period of time where we had quite a lot of legal uncertainty. And I remember after reading the Schrems II decision and having the privacy shield annulled, the adequacy decision annulled, I remember thinking and also expressing this publicly that, oh my God, if we were to apply this decision as it is, as I'm reading it, we would indeed need to stop a lot of the internet and online activity and trade and communications in between the EU and the US. To a certain extent, this decision kind of confirms, my reading from back then. So again, I'm trying to just be very short. This concerns that particular period of uncertainty, legal uncertainty. And it raises a couple of very interesting legal questions. One of them is indeed this relationship in between having the GDPR being directly applicable to an entity outside of the European Union who offers services in the European Union and transfers data in that context outside of the EU. And whether in this situation, this foreign entity would need a lawful ground for transfers on top of the fact that they're directly subject to the GDPR. And there have been many opinions in this sense. I believe that you do need some additional transfer mechanism in this space, but perhaps Professor Kunar will give us a bit more nuance about that. So that's one very interesting legal question, because one of the defenses brought by Uber in this case was that because the GDPR, they are directly subject to the GDPR, they would not necessarily need another mechanism for transfers in that particular period of time. Very important, however, is to say that they were willing to rely on SECs up until the point where the European Commission published their new decision on SECs, where the European Commission made it clear that that particular set of new SECs cannot be used by a company outside of the European Union, which is directly subjected to the GDPR. So, SECs were kind of out of the question for Uber if they had to and wanted to, follow strictly what the European Commission was saying there. So they would have either taken the position that being directly subject to the GDPR, they don't need mechanism for transfers, or find another alternative. But SECs were out of the questions. So what was there available? They looked at derogations, and I think there is a case to make that in this particular context, the derogation for necessity to enter a contract, because the context involved drivers that were entering a contract with Uber and were under a performance of a contract with Uber, could be, argued at least. However, the Dutch DPA disagreed with this solution that Uber found for their to cover that particular transfer. I will stop here because I really want to get into some deeper thoughts about this state of facts.
Chris, let's bring you in.
Yeah.
Start where you please, because there's so much going on here.
Thank you very much, Jules, and thank you for having me. I'm not going to say very much for several reasons. First of all, I know time is limited, and I don't want to take the time up of others to speak. Secondly, I confess I haven't not yet had the time to read this decision in detail, and I'm always extremely cautious of opining on something that I haven't read yet in detail. I think this sort of case too tends to be very fact specific, so you really have to know all the nuances of it. So I'm not going to express an opinion, was the Dutch DPA correct or incorrect in their decision. What interests me most about this decision is the issue about the interrelationship between the direct application of the GDPR and the data transfer mechanisms, which seems to be one of the salient issues in the decision, from having kind of gone through it a bit quickly, skimming it and reading a few sections of it. This has been something that has been plaguing us really going back as long as I can remember. In fact, I went back and I wrote about it in my first book, which was published in 2003. So this has been going on for quite a long time. And I'd like to say we're a bit closer to a solution. I think it's good that the Commission and the DPAs through the EDPB have at least recognized that this is an issue, and they've tried to opine on it. But frankly, I'm not very satisfied, and I've said this in my writings about the result in terms of just the clarity and ability to comprehend what they've said. I find a lot of it extremely confusing and a bit disorganized. I think this is an issue that we're going to have to go deal with quite a lot in the future. I can also say maybe a little bit of a inside Brussels view of this was that this is something that's been very controversial in the EDPB. There have been different camps about it. Should the fact that you're subject to the GDPR under Article 3 take away in some way from an obligation to have a data transfer mechanism or not? Some say yes, some say no. I think the Commission has been sort of pushing to recognize this, to allow more, that if the GDPR applies to you directly, you don't have to have a data transfer mechanism. I'm a little bit skeptical of this view. I also think both the Commission and the EDPB have not really fully explained their reasoning for going into this issue. They just sort of came out with this opinion. I did talk to some of them as they were drafting, and make my views known, but it doesn't seem to have done very much. So really, this is something that's going to continue to be a problem. I think, if anything, from my just skimming of this opinion, what it does show is if you're a multinational with establishments in the EU, claiming that you don't need to have a data transfer mechanism is going to be quite risky. I would generally kind of advise against it, but again, it depends on the facts of the case. And one more point, if there are any DPAs watching, I did note in the Dutch opinion, I found a few places where it seems like there has been some copying of some of the things I've written in some of my articles without citing me. So I would say, dear DPAs, I'm very happy if you're reading what we write, that's great, but really it is best practice if you're going to kind of then adopt the passages to at least cite to it, please. I think that's the only fair thing to do. So I'll limit myself to that and turn the floor back over to Gabriela.
Crystal, I want to quickly ask you one other thing, though. The derogations in general, the notion of relying on them, obviously the DPAs over the years, primarily, frankly, before Schrems had, initial guidance that severely restricted what might be the plain reading of some of the derogations, arguing that if they're, repetitive and significant and so on and so forth. Others have pointed out that that's not language in the GDPR for each of those derogations. And we keep posted on our website a video where the head of the court challenged at a German conference by a lawyer who said, you guys created a legal void. And he said, by no means did we create a legal void. There are derogations that can be used, particularly for intercompany transfers. And we kind of keep that language there. And every so often we're like, I wonder whether the court embraces the narrow view that the EDPB has taken about the use of derogations. Maybe the good that will come out of this is we'll hear what the courts actually think when they read the text. Do you have a take on the derogations and how they might be used at all? Because right now it seems like hardly anybody uses them for anything in any significant way whatsoever.
Well, indeed, this has been this narrow view has been always the view of the DPAs. But I think there are respectable arguments to make that perhaps this view is not really anchored in the text, and you could maybe justify taking a bit broader view. I do shake my head when I see the court say one thing and then a justice of the court in a conference kind of opining on what they said and seems to say something else. I just really wonder what's going on there. I think this has to be dealt with by the EDPB or by the Commission. I can also say I'm a member of the multi-stakeholder expert group of the Commission on the GDPR, and I have said in our meetings to the Commission, please, you need to clarify this issue about the derogations, because really there's a lot of legal uncertainty here. But I think I'll leave it at that. Thank you.
Odia, what do you say?
So first of all, thank you for inviting me. And I'm here in the presence of greatness here and looking at Professor Kuhner's book in my privacy tree right there. So what do I think? I think, so you know that my tagline on this is cry and pray, right? And so when representing companies and multinationals that are dealing with this, what a company reads this and says, okay, well, what am I going to do now? And so what are companies? What are the takeaways for companies here? So I guess the first thing is you need the standard contractual clauses, even if you don't think that you need the standard contractual clauses, and importantly, right? So that's the takeaway, right? Like the takeaway is you need the standard contractual clauses, and you need to make sure that you comply with them, and you need to make sure that you're implementing them, and you need to have the protections. The second takeaway, which is, I think, unfortunate, is that, companies basically need to err on the side of caution, even though they were told specifically you can't use this instrument because this instrument is not appropriate. We're working on other instruments that will be appropriate. But if you now didn't use the instrument we told you that is not appropriate, you get hit. Not only is this a violation, but it's a significant violation with a significant fine. And that's a really difficult message for companies to deal with just generally, right? This specific issue, okay, has maybe a solution you think is obvious. But I remember when this came out, and we read this and we had, like chats with all my privacy geek friends about this. And then the clarification came out. And then I know that companies were doing both. Some of them were waiting and seeing because the commission told us to. And some were saying, you know what? Kind of like we did with the old contractual clauses, that we used them backwards before we had module 4, and we knew that we couldn't use them backwards. But I mean, the logic that I had applied at the time, and the logic that applies here too, is okay. So there was this concept of ad hoc clauses that wasn't really used. But if ad hoc clauses are okay, and here are clauses that we know are okay, so if we use the clauses that we know are okay for a situation they don't work for, maybe they can serve, kind of substantively serve the purpose. So that's kind of one, I guess, takeaway. The other takeaway is reading the opinion, which I read again this morning, is there are a lot of statements there that if you take them specifically, they have a lot of really big meanings for what is direct application of GDPR. There was a statement that basically said, if you're a US parent and you have an EU subsidiary, the very fact that the EU subsidiary generates revenue that you benefit from a US entity puts you in direct scope of GDPR. It also said things like, if a person enters into an agreement that they don't have much leeway around, then that's no longer, like, there has to be another controller in there because your data subject don't have any influence. So there are a lot of statements there. Two more points, so I don't talk over too much. One is with the derogations, right? So the derogations, this issue, when we were in this limbo point, I actually even remember, now I don't remember where this webinar was, because if I did, I would find it. But there was an interview with Max Schrems about the Schrems 2 decision. And somebody said, but US-based multinational centralizing storage of the HR function, right? Which, in my opinion, is kind of the most innocuous use of cross-border transfer. This is not commercializing information. This is not targeting or profiling or uncontrolled third-party sharing to infinity, right? This is like, I am a US company that, the HR HQ is in the US and I need to store my HR stuff there. So is this a situation where I get penalized? And he said, no, this is not a situation that we intended to go after, right? But here is a situation. It's not exactly the same, but it's account data. And in reading the opinion, if I missed it, and I did not read it in Dutch, I read the translation into English. So if I missed it, then I apologize. But there was nowhere that said, ooh, this is misuse. This is sharing. This is commercializing. This is wrong. This is a use for the purpose for which it was intended. No statement of a not fair play, right? But you can't use the derogation, one, over a technicality that it's not, that it's systematic and repetitive. Okay, even though for the DSAR part, they said there were 25 DSARs a year. So I don't know if that's systematic and repetitive. Maybe it is. The other piece which was concerning is they said that you can't use the necessity component because it is not objectively necessary, because Uber said it is faster and more efficient to centralize it, and faster and more efficient is not necessary. And I am not sure that I agree with that messaging for multinational companies. And then the final piece is, there's the legal reasoning, right? So when I talk to clients and associates and everybody, I sort of say, okay, well, this would have been a great law school exam answer, but like in real life, what do we do? So let's say you go through the reasoning, but at the end of the day, right, there's a huge fine. Where is the damage? Where is the statement or, explanation that there was actually inadequate protection? There is an assumption that says this was transferred to the US, that subsequently was held to be adequate, right? And there was no sharing, there was just storage and technical processing. So where is the, so yes, let's say there's a technical foul, okay? There is a transfer, there wasn't a mechanism, okay. But the mechanism isn't an end, it's a means to an end. And the end is adequate protection of the data. Where was the inadequate protection? So that's the part that I think companies, when they are we don't live in a perfect world. Clients can't do perfect things. And there's always some sort of compromise. And when we do this, we usually look at the risk and the risk and the impact. And you say, okay, well, if there's no risk, this is probably not risky. But in this situation, it's 290 million euros worth of risky. So I think companies are in a, kind of difficult position in this situation.
Gabriela, Chris, I want to ask you this. You have the Clearview AI situation, for example, right? Collecting data remotely from the US in a way that may be subject to the GDPR because of the profiling, because of the crawling, because of the nature of what's going on. And I think that's one interesting kind of way to debate this question. But what was happening here is a little bit different. There's a joint controller relationship here for a European company, right? Uber Transport UTI, that has a DPO that is fully 100% subject to the GDPR. Should we be thinking about that differently than sort of should remote players who are technically covered by the GDPR because of the scope and the ability to regulate people, even if they're not sitting in your district, but because you're acting on data subjects in your district? Clearly, we understand that that's one of the reasons why we have these various additional mechanisms. Is the joint controllership and the fact that this is a European-based entity relevant here? Chris, I wonder your thoughts.
Yeah, well, just very briefly, and let me build a bit on the great comments of Odia, which I really thought were right on point. But indeed, I think it does make, without, again, opining on a specific case or a specific company, but clearly it does make a difference if there's some controller in the EU involved, because really what they were trying to capture, I think, for example, in this EDPB guidance 05/2021, I think is the title of it, are situations where there's some entity, organization, company outside the EU which is interacting directly with parties in the EU, but without having an establishment in the EU. So going over the web directly, dealing with them. And that's obviously not going to be the case with most multinationals, because they will have an establishment in the EU, which then, if you look at the Google Spain judgment, this sort of then catches you, brings you into the GDPR, including the data transfer provisions. So I think it does indeed make a difference. And probably this is maybe one of the faults of these statements about this by the Commission and the EDPB, that they may be giving the impression that they're trying to open a broader or make a broader opening for avoiding the application of a data transfer mechanisms than what they really intended.
For what it's worth, I also think it should make a difference, at least when it comes to the proportionality of the sanction, even if we're thinking about it in this way. And I think it's very interesting, Jules, you're bringing into the conversation Clearview AI, because the same data protection authority, the Dutch DPA, had actually fined Clearview AI in the past week or so, but if you're looking at the sanction, it's 10 times smaller than the sanction for not having the lawful grounds for processing in place for transferring driver data to the company that is in a relationship with those drivers. So, and yeah, I don't know. It's a bit of a perhaps an unfair disconnect if we're taking two steps back and we're looking at the two situations and comparing those situations. Before I know we're already at time, but I was just thinking, hearing to Odia's comments and knowing so much of the scholarship of Professor Kunar, if indeed we should question the edifice of the international data transfers system and how it's laid out and enforced. And I think Professor Kunar's latest blog, where he brings into conversation, for instance, the question of rule of law, the rule of law, and how transfers to third countries outside of EU that are not, let's say, poster childs for rule of law, how would those weigh into thinking about this building, this edifice of international data transfers under the EU?
And in fact, we should note that Yango, the Russian-owned transportation service, evidently had some complaints filed against it in a couple of jurisdictions, including in the Dutch jurisdiction, and evidently have had no negative action. So I do think, in terms of questioning the legal edifice, when we're all looking at this and saying this is kind of a legal mockery and a morass, I can tell you, just talking to lots of senior folks who have to explain to their business executives, the logic, the morality, and so forth. They say, well, what should Uber have done? I said, well, they should have used standard contractual clauses. But I thought you told us that at that period of time, that was not actually acceptable because we were in the post-Schrems world, and the EDPB's views as to how you could create SCCs that would somehow prevent the authorities from accessing it would not have sufficed. So it's interesting to think that if Uber had thrown up SCCs, sort of the pragmatic, it don't work, but let's just put that paper in place, what would the Dutch authority have done? Either they seem from the decision that that's what they think Uber should have done. They either would have had to make this determination that, sorry, you cannot rely on SCCs, but and because there's a complaint against Uber, we're taking action. We're just not taking action against every other company in the world that's doing the same thing, or this alternative. So anyway, it isn't the same.
And that's the part that's missing for me, right? Because I thought, and you guys know this better than me, but I thought the whole point about the Schrems case and the issue was that, and Matt Schrems kept saying, people just execute SCCs and put them in the drawer and don't look at them. So now, if you put the SEC in place and do nothing different, then it would have been okay. Or if you didn't have the SECs, but you had things in place, but we don't know what they are. They were not analyzed in the decision, right? But the way that I try to think about it is like, what's the point here? And the Dutch DPA also makes points about why the relationship between Chapter 5 and Article 3, why Article 3 is important, because we have direct application of GDPR. We have the better ability to enforce, the better protection. Okay, so then what's the point? The point is the better protection. So if when talking to clients, I try to say, okay, well, what's the end result here? Forget like the paperwork, even though boilerplate paperwork is required, and without it, the SECs are, not effective. But like, what's the point? The point of the protection. So the question is, how do companies think about it when, what are they trying to solve for? What should the protection look like? That's the part that is missing for me, and that's the part that I think companies want to know is what does compliance look like? We know we missed the paper. But like, what does compliance actually look like so we know what to do?
All right. I don't want to keep anybody. Any key, quick last thoughts, Gabriela or Chris, that you want to chime in on before we wrap? No? BCRs, no, I don't believe Uber had BCRs. One of the questioners asked. I believe it is a 6-year wait if you would like BCRs at the Dutch DPA, and obviously long waits at others. And again, why would BCRs have made a difference if SECs didn't make a difference? The language and the promised protections when you don't have the ability to guarantee, appropriate surveillance oversight back home. Again, it would have been equivalent to just throwing up SECs that you knew were not adequate. No, we're not saying that not having a headquarters or people in Europe means you're not subject to the GDPR. You absolutely are under the scope of the GDPR. The question is whether or not a remote collection and the transfers of those entities, what model they fit in. Do you need SECs if you're in the DP in the trusted transfers program, shall we call it? No, you don't. That's the point of having that contract. Anyway, thanks for those of you who've chimed in. Chris, always wonderful to see you. Hopefully cross paths in person soon.
Thank you.
Thank you. Gabriella, have a great weekend. Thanks, everybody. We'll answer some of the other questions in the comments. And please, if you don't have version 1 of the GDPR commentary, it is being cited by the ECJ already multiple times. Gabriella has had articles in it that have been cited. So the court is reading it. So you should be reading it. Thanks for joining us. Have a great weekend, everybody.
Thank you. Bye-bye, everyone.
Thank you.
Yeah.